course of a day at WVAR, we get so many questions about the law and about ethics and disclosure law and earnest money that we thought that this edition of WVAR Briefing it would be helpful to devote it to sit down with none other than WVAR legal counsel and the voice of the legal hotline, Brad Sorrells, to talk about a few of these issues. All right, we're here today with Brad Sorrells, the voice of the WVAR legal hotline and our general counsel. Just talk about a few issues that come along. Brad, let's just start out. Thanks for being here, by the way. Let's just start out with a generic kind of what's the most common question, complaint, issue that you hear in the legal hotline when our folks call in?
Well, thank you, Ray, and thanks for having me. Well, I guess if there was a most common question I get, it's probably about defect disclosure, and particularly with respect to stigmatized property, and or a subset that kind of falls into that. I don't know if it's necessarily a stigma, but what do you do when you have a sex offender that lives nearby or next door, that kind of thing.
Okay, let's just follow that along, and let's talk about seller disclosure and disclosure law in West Virginia, since that's kind of that commonality question. So, what is we here's so many urban legends, and you and I have had these conversations many a time about you have to disclose this and you have to disclose that. So the bottom line is, and I know you and I feel the same way, if you know it, then you need to contemplate disclosing it, as long as it doesn't require seller permission to do that. But otherwise, what do I as a real estate agent have to disclose by law?
Okay. Well, in West Virginia, there's no statute or regulation which requires disclosure of anything. The disclosure requirements are created by the common law, case law, published opinions by the West Virginia Supreme Court of Appeals. And what those cases require is that the seller or the seller's broker disclose any known defect or condition that substantially affects value or habitability if that defect or condition is not known by the buyer and it would not be discovered by a reasonably diligent inspection. And tying back to what you asked me about on my common questions, one of the things is, there was a suicide in the house. Do I have to disclose that? But one thing you might think is, if I'm thinking, do I have to disclose it? That means you don't want to disclose it because you think it's going to negatively affect the transaction, and that's taking you a long way toward the end result of, does this affect value or habitability? If it didn't affect value at all, you would say, well, I don't care if I disclose that. But what I routinely tell people when they call up about a suicide, for example, excuse me, I'm not positive whether that's a defect or condition. Some people might argue, well, no, that's not a defect or a condition. That's an event. That's something different. But the decision on whether that's a defect or a condition is above my pay grade. At some point, that's going to be decided by the justices of the Supreme Court. In the meantime, if I'm a broker, I don't want to be the test case that gets to decide that. And so I tend to look at that one, for example, from a more pragmatic point of view. And that being that it's not even a question of if the buyer is going to find out, it's when the buyer is going to find out. Because wherever that happens, the neighbors know about it. And if the buyer doesn't hear about it before closing, they're going to hear about it after. And if you happen to have a buyer that just can't live with that would have walked away from the transaction, well, that might be the same buyer that's going to sue you about that. And eventually one of those suits is going to make it through the system and up to the Supreme Court. And then I'll be able to say, oh, no, you do have to disclose that or you don't. But until then, it's kind of a gray area. But it's a gray area that's fraught with risk.
What about is a suicide, for an example? And I understand what you're saying, but would that be an issue that you would, as an agent, as a seller's agent or as a listing agent, listing broker, would that be an issue that you would have to have the seller's permission before you disclosed if you knew it, or if you knew it, do you think you could just disclose it?
Well, I think you'd probably have to have the seller's permission, because it's not clear at this point whether it does constitute a defect or condition. And so if you have a seller saying, I don't want that disclosed, I think you probably you need to figure out where you want to be with that transaction. Do you want to continue to be involved in it, aware of what the risks might be? I mean, it could get really complicated. You don't want to be getting into necessarily indemnification and defense agreements with your seller.
And by that same token, too, though, I could see where someone could say that, and I hate to be morbid, but you know, when I was 5 years old, I walked into the kitchen and saw my grandmother had hanged herself, hanging in the kitchen. So to me, that is a habitability issue. I can't live in a house where someone's killed themselves because I was traumatized. So I mean, I'm not making that argument. I'm just saying I can see how that could be an issue either way because of that. So let's take that to the next step then. You know, we're not a mandatory disclosure form state.
Right.
We're a voluntary form, and as such, with the 16 boards we have, while we have a sort of a recommended draft that you worked on, all the boards or most of the boards have their own version of this voluntary seller disclosure form. That some that are 2 pages, some that are 14 or 15 pages of disclosure. So since they're voluntary, maybe it doesn't matter if they're voluntary, but what's the liability for a board or a broker who uses these voluntary disclosure forms?
Well, the liability can come into play because with those forms, once you start filling out things and going beyond what the case law requires, so now you're not just telling about defects or conditions that substantially affect value or habitability. You're going through a whole laundry list, so to speak, of this about the house and that about the house. Each one of those is a representation, and every time you make a representation to someone, in this case it's a written representation, they're entitled to rely on that. And if it turns out that that's false, that could be a point of liability. Not only are they entitled to rely on that, but previously, if you just not made any disclosures at all, because say, for example, there were no defects or conditions like we talked about, well, if they were interested in these other points that are on the disclosure, it would be up to them to go and determine it. It would be up to them to have somebody look at the roof and see if it was in good order, or look at various fixtures in the house. But if you're telling them what the condition of all those things are, they can rely on them. And if your representation is wrong and it's substantial, that could end up in a lawsuit.
Now, do you think I mean, I realize that the initial lawsuit nest is cast very broadly, is cast very broadly. But so let's say I'm a local board, and I've had my local attorneys or my local brokers prepare this voluntary disclosure form, and I give it to all the brokers to use. So one of the brokers of the local board uses that disclosure form. Obviously, it's a seller's disclosure form, and it's seller's information. So the seller is liable. I understand that if they put false information on there that they knew, and the buyer relied on that information. But where do you think the liability stops there?
Well, it can. Brokers and agents need to be careful that they're letting the sellers provide the actual information. If the broker or agent gets involved with that and is actually filling out the form, they've essentially adopted that, and that comes up in cases.
So stay away.
Yeah, I mean that really needs to be up to them. I mean, you can maybe perhaps explain what a form means, but the information that goes into it needs to be the seller's.
Okay. What about and let me just take this, because we do have we have this belief in the real estate business that every time something happens, we need to add another piece of paper, something to the contract, to the form or somewhere. So when you get these giant voluntary disclosure forms, I've often thought, and I'm not an attorney, but I've often thought, do we put ourselves in peril? Is someday a judge going to say, good grief, you can't expect someone to actually read and fill out and understand those 25 pages, those 15 pages. You need to simplify this, man. especially as we go, as we go online and do these things, we make it so much easier to click and initial this, that. It's kind of like how many people have actually read the agreement before they click check the box that it says that. We don't do that, but yet we expect all of our clients to on dot loop and stuff. Is there any liability to continue to add pages and pages of information?
Yeah, I can see the point you're making about a judge saying that something's unreasonable, and contracts get set aside all the time because they're not reasonable, or they're ambiguous and not capable of discerning a clear meaning from them. So I don't know that just by adding layers of paper that you're adding layers of protection. In many cases, by adding more paper, you're adding more points of attack for somebody who might want to be suing sellers and brokers and agents. The thicker a contract is, there's more clauses you can go through and say, well, this one wasn't followed and that one wasn't followed. So more is not always better.
So would you say, and I've heard litigators say this on the defense side of things, that it's their job to create doubt. And just like you said, the more pages I have, the less doubt I'm able to create because it's all there. And
Well, I don't even know if I agree with that. The more pages you have, the more places you have for doubt to occur. I mean, it's sort of like a machine. The more moving parts you have, the more places that can break down. So a really simple machine, a screwdriver is a machine, they don't break down very often. But when you start adding more parts and they all have to function together properly, you've got more room for breakdown. And you get into a longer and longer contract, and it becomes easier to see where paragraph 7 all of a sudden conflicts with what somebody filled in the blanks on paragraph 37. And you get ambiguity in a contract, or people skip blanks that should have been filled in, and those are all points for trouble.
So it's let's take it one step further. Then we've talked about this before, but it's the disclaimer versus disclosure issue, and there are many states that have gone to disclaimer, which basically is sort of a caveat emptor. All states have the latent and material defects disclosure law. If you know it and it's hidden, you have to disclose it. So taking that aside, there are states that are saying, look, we're going to sign a piece of paper that says we don't know anything other than the latent material defects issue. And any of this stuff you want to know, I'm not going to sit here and speculate how old the roof is or what kind of condition the heating and cooling system is. If you want to know these things, here's a list of inspections that you ought to consider, but it's up to you to find out. What do you think about that in terms of protection for the agents and the sellers?
Well, I don't have a problem with that at all. I mean, as long as you're meeting that minimum baseline of complying with the hidden defect or condition, you don't need to tell anything. And if you're not saying anything, if you're simply saying, I'm not aware of any defect or condition that substantially affects value or habitability, you're completely in compliance with the law, and you haven't made any representations that might turn out to be false. And I know people that sell their own houses that way. They don't feel like it's any benefit to them to be making these representations.
Kind of the as-is thing, and that's what I've bought enough property in my day, and I'm not going to say I'm normal or common or the average buyer, but I've never felt like I wanted to rely on any seller's form. I wanted my own inspections. I wanted my people, so to speak, that I pay to go in there and inspect all these things to know. So, but I find it interesting that what you said was, but if I write something down as a seller, even if I'm not sure, I own it at that point.
Correct.
Because I said, and if you relied on it, and in fact, didn't we, when we filed that amicus brief with the Supreme Court case, wasn't that what the lower court judge said, is it was clear the buyer didn't rely on a disclosure form, and that's why it wasn't was that the...
I had to remember which case you were talking about. Yes. In that case, they were arguing some problems with the disclosure. As a matter of fact, in that case, one of the plaintiff's arguments was that the disclosure form was wrong, that the seller should have filled it out differently, and argued that the broker or the agent had a duty to go in and check the disclosure form and correct mistakes. And I didn't represent the agent in that case, but the agent's counsel was able to say, no, Judge, it says right here on the bottom that these are the seller's disclosure and the agent doesn't have any knowledge about them and it hasn't checked them for accuracy. And that was a good example of where, had that agent assisted in the filling out, or maybe sat there and asked questions and done the checking, that somehow taken ownership of that form, instead of getting out of the case on summary judgment, that agent probably and her broker probably would have been found liable.
Well, so what would you say, at the risk of me putting you in a position to receive hate mail and hate phone calls, what would your thoughts be in terms of, if we have all, in terms of liability for the agents and brokers, and maybe the sellers to an extent, but in all these different voluntary disclosure forms out there floating around, some are a couple of pages, some are 14, 15 pages, versus the concept of just that disclaimer where everybody used the same thing and it said, it's up to you to find these things out.
Well, you've got a couple competing concerns here. The way I tend to look at it is from a limitation of liability issue. But realtors are not, they're certainly concerned about limiting liability, but limiting liability is not how they make their money. So they make their money through sales, and to the extent disclosures and having a buyer that feels like he's been told lots of information promotes a successful transaction, it can be a great tool. But there's always a balancing act there. You want to give them enough information that it's helpful, but not over inform so that you're creating liability. And what I might like to see, if a case comes to my desk and there's claims involved, might not be what's best for 98% of the transactions which are going to sales.
Okay. Makes sense. Yeah. Any before we wrap up, any final thoughts that you want to tell them about disclosure and tell realtors, tell our members?
Well, one thing I'll go back to talking about that stigmatized property, and my general advice that is, you need to disclose it because they're going to find out sooner or later anyway. Well, the person that's going to find out sooner or later anyway is the person that actually buys it. So I don't recommend that on something questionable like that might be a big deal and might not even be required, that you write it down on the disclosure form. It just needs to be disclosed once this is progressing towards a committed transaction. So if you've got somebody submitting an offer, before you accept it, say, okay, I need to let you know this, and this might be of interest to you or concern. So at that point, you've made your disclosure, but you don't have to have it up on the MLS. Caution: this is stigmatized property.
Thanks for joining us for part one of our discussions with legal counsel and voice of the legal hotline, Brad Sorrells. Part one, we talked about disclosure, seller's disclosure, and disclosure issues across the state. In part two, we will be talking about earnest money. Thanks for listening.